appellant, together with my learned colleague, Mr. Van Zyl.
Thank you, Mr. Senior.
As it pleases Justices, I appear on behalf of the third respondent in this matter with my learned friend, Mr. Kutumela.
Thank you, Mr. Jube. Thank you, Mr. Sile.
Thank you, Justice Shulby.
Well, before you start, may I just ask you, I know you have prepared, your submissions. May I ask you to state your roadmap,
Yes.
as far as how you want to proceed?
As you please, Justice Shongwe. We submit, Justice Shongwe, Justices, that there are two issues before you to decide. The first issue is the question whether there is indeed an effective internal remedy or was an internal remedy available to the appellant to follow at the stage when he approached the High Court. And secondly, and this is only we submit an issue that will become relevant if you are against us on the first issue, and maybe I should then just make the submission that we submit that the court a quo was with respect wrong in finding that there was indeed an effective internal remedy available, as we would submit was the first question to be decided. But even if you are against us on that, or only if you are against us on that, then the second issue will arise, whether exceptional circumstances was in fact available, or there were exceptional circumstances justifying an exemption from the obligation to exhaust internal remedies as is required in terms of Section 72C of PAJA. The court a quo indeed found on both issues against the appellant, and the application was dismissed on that basis, that there was an internal remedy available and there were no exceptional circumstances. So those we would submit are the issues. We respectfully submit that the court a quo in fact faulted in both these respects. And if we can start off with the first issue, that is the question relating to the issue as to whether there was in fact an internal remedy available to the appellant at the stage when he approached the High Court with the application relevant to this appeal. The first submission that we wish to make, Justices, is that although it is not specifically mentioned, it should be an effective internal remedy available. It shouldn't be a remedy that would not be effective in curing the specific complaint that a person raised in the proceedings.
Now, how do you read Section 10(3) of the Act, the Health Profession Act?
10(3), Justice Shongwe reads, an appeal committee referred to in subsection 2 shall have the power to vary, confirm or set aside a finding of a professional conduct committee established in terms of section 15, etc. So the important words we submit is set aside a finding. And that is indeed an extremely important starting point, but of course we submit that one should read the relevant section with the regulation, and in that regard we refer to regulation
finding that you are challenging is the finding that the members of the disciplinary committee were not obliged to recuse themselves.
Yes.
Now, if that finding was set aside, what is the effect of that upon the proceedings?
On the proceedings, well,
Yes.
of course, then the effect would have been that they should have recused themselves and that the court should have made the finding that they have to recuse
Yes, but
themselves.
what is the effect of a finding of bias upon a Prasada in a court of law or a tribunal? What effect does it have on the proceedings?
Well, that makes the proceedings void, I would submit, Justice Swain.
Well, you see, I think what it does is that if there's a finding, it means that the proceedings are a nullity. So if it is a nullity, do the proceedings stand or do they have to be set aside by way of a review?
Well, of course, if the presiding persons recuse themselves, I would submit that there would be no necessity to indeed set the proceedings aside.
Will you see then in the decision of council review, SADF and others versus Monig, a decision of this court, 1992, volume 3, SA 482 at 495, this court dealing with the issue of recusal, in the following passage, if, as I've held, the court-martial should have recused itself, it means that the trial which it conducted after the application for recusal had been dismissed should never have taken place at all. Yes. What occurred was a nullity. It was not, as in many cases the cases quote to us, an irregularity or series of irregularities committed by an otherwise competent tribunal. It was a tribunal that lacked competence from the start.
Yes.
The irregularity committed by proceeding with the trial was fundamental and irreparable. Accordingly, there was no basis upon which the Council of Review could validate what had gone before. And this is the important passage. The only way the Council of Review could have cured the proceedings before the court-martial would have been to set them aside. Right. And that's consistent with decisions that a decision in a disciplinary inquiry is an administrative decision, and with Odekral, where an administrative decision stands until it's set aside. Now, does the appellate tribunal in this case have the power to set the proceedings aside?
I would submit no.
So then is it an effective remedy to go to the appellate tribunal?
It's not an effective remedy. Justice Swain, I would submit that the court or the presiding persons, if it is a tribunal that one has to deal with.
But isn't the bias principle derived directly from the Constitution? In other words, Section 34 guarantees the rights to have disputes decided in a fair public hearing Absolutely. Before a court or, where appropriate, another independent and impartial tribunal forum. And the Constitutional Court in Burnett versus Absa said that this presumption therefore flows directly from the Constitution. The authority of the judicial process depends upon the presumption of impartiality.
Absolutely, I agree with you, Justice Swain. The basis for recusal and all the decision on bias stems from the Constitution and the right to have a fair trial if it's court proceedings and or fair administrative procedures if it is indeed an administrative process.
Mr. Salier, does it not, just on the adverting to the point that my brother Swain put to you, as was held in Burnett, the Section 34 right is implicit, as the court said there, Constitutional Court. It's either implicit or explicit in the requirement that the tribunal, because it talks about a tribunal or a forum. Section 34 is implicit in the rule that the tribunal must be impartial. Yes. Not so.
Yes, absolutely. Yes.
Now, the Section 34 right was not taken by you, was not raised by you at all in the papers. Is it competent for this court to have regard to the Section 34 right? Firstly, let me just understand this. Am I correct in my assessment that you didn't raise Section 34 squarely for the respondent to deal with this?
Well, Justice, I would submit that was the very basis of the application. And at this stage, what you must, with respect, remember is what is before you is not the question relating to that issue specifically. The question that this case was decided on was only two issues, as I mentioned in the beginning, whether there was in fact an internal remedy, and secondly, whether there were exceptional circumstances if you indeed hold that there was an effective remedy. So the issue of the fairness of the proceedings is not at present before you.
No, I accept that, but what I'm saying to you is the Section 34 right, the fact that we have to take it into account, where does that power come from?
Well, you have to apply the Constitution, Justice.
Does it not reside in Section 39 too? That when a court has to interpret legislation such as this piece of legislation, the Health Professions Act, that it has to take into account it's got to interpret it in such a way that gives effect to the spirit, purport, and objects of the Bill of Rights.
That is an overriding principle entrenched in our law, and with great respect, I would submit it will always apply not only to a court on appeal, but to all courts and all tribunals.
So on that basis, the court has to have regard to Section 34.
Yes, absolutely. And to all other fundamental rights of the parties involved in.
And then one last question on this aspect, Mr. Celia. Is there any provision, does Paja Section 7.2, which prescribes the exhaustion of an internal remedy? Is there any case or is there any principle in law that allows an internal appellate body, or let me put it more directly in this case? You've referred to Section 10.3, or you were referred by my brother presiding to Section 10.3. Does Section 10.3 allow for an appeal where the lower body, in this case the Professional Conduct Committee, does not have jurisdiction?
Absolutely not. That is the argument, Justice Schippers, that we intend to develop before you, because we submit that if one has full regard to the regulations, then this becomes absolutely clear that there is no jurisdiction for the appeal committee to decide on an issue of this nature.
So just for my own understanding, I thought initially you were saying that the issues that we have raised that are before us are two issues. I thought there were only two issues. This other issue about Section 34 and all that, it was not raised before the High Court. And the other parties never had an opportunity of dealing with that issue because it was not raised at the High Court.
No, Justice.
They dealt with the two issues that we have raised before us. Can we now get into other issues, for instance, Section 34, which was never raised in the High Court?
Justice Sariti, with great respect, we are, in the first instance, in order to establish whether there was an internal remedy, the first step to be taken, I would respectfully submit, is to interpret the section creating the appeal committee and the regulations. And in that interpretation, one has to follow the approach suggested by your brother in the question before you raised this issue. So it's implicit with respect in all interpretation of all legislation and or regulations that a court should do it against the background of the Constitution.
Was that the issue that we raised in the High Court? Was that issue ever raised?
That's the very basis of the argument.
No, my question is, was that issue raised that the interpretation of Paja and this Section 10.3 depends on Section 34 that we are relying on?
Justice Sariti, it's a long time ago, it's 2 years ago that the argument was done, but I can assure you that the interpretation in accordance with the constitutional principles was the very basis of the application.
But then it doesn't appear anywhere on the judgment of the High Court. I tried to look at that judgment and I couldn't.
Even if the court I quote didn't specifically refer to that, it is such an trite situation that I would submit that no High Court will ever interpret legislation and or regulations if it doesn't do it in accordance with the principles laid down in the Constitution. I don't think, with great respect, that courts will always, when they interpret some section, always refer to section 39(2) and or to section X of the Constitution. It's such a basic principle that it always applies.
Mr. Cilliers, but the issue is whether the remedy of an appeal to the appellate tribunal is an effective remedy.
Yes.
In Kuyabi, the Constitutional Court said that in a constitutional democracy like ours, where the substantive enjoyment of rights has a higher premium, it is important that any existing administrative remedy be an effective one.
Yes, I suppose
So the
you
issue
refer
is-
to the Koyaba.
So the issue is whether the appellate tribunal, in terms of section 10(3), interpreted in the light of the Constitution, provides your client with an effective remedy to challenge the refusal by the members of the disciplinary committee to recuse themselves.
Absolutely, I absolutely agree with you, Justice Swain. All that I would add is not only 10(2), but one should also look at the regulations that was in fact promulgated in terms of this Act and prescribing the procedures to be followed, because that can be of assistance in the interpretation of section 10(3).
Well, you were just about to refer to Regulation 8. Before you were interrupted, you were about to refer us to Regulation 8.
Yes, as far as we submit, justices, we submit, one must have also then regard to the regulations in order to establish whether an appeal to the appeal committee could ever be regarded as an effective internal remedy. And I would submit that we should start off with Regulation 8.2 and 8.3. 8.2 of the regulations Sorry, 8.1, we should start with. The accused or pro forma complainant may appeal against the finding and or penalty of the Professional Conduct Committee.
What page is this at in the bundle? Is this
The
your,
regulations wasn't part of the...
aren't they part of your appellant's authorities? Page 208.
Sorry,
It's on page 210, I think. 210.
210.
But then that's Regulation 11.
Justice Swain, there's a bit of confusion.
Yes, I know in your heads you refer to Regulation 8, but when I looked at this bundle of authorities, and it appears to be the regulations starting at page 208, the regulation you're now referring to is described as Regulation 11 on page 210.
Justice Swain, I think what created the confusion was that this trial commenced at the time of the existence of the previous regulations. I must apologize, Justice Swain. It appears as if the new regulations was included in the bundle, whereas the trial, it was common cause that the trial should have been proceeded with based on the previous regulations.
Is there any substantive difference between the two sets?
I quoted, maybe if you can look at the first subsection under the heading appeal, that is in the relevant, or that has to be relevant regulations was 8.1. It read, the accused or pro forma complainant may appeal against the finding and or penalty of the Professional Conduct Committee to the Appeal Committee.
That's entirely different.
Yeah.
This reads, the respondent or the pro forma complainant may appeal to the Appeal Committee against the findings or penalty of the Professional Conduct Committee or both such finding and such penalty.
Well, the gist, I would say, is exactly the same, Justice. So I sincerely apologize for the situation. Our submission is that if one look at that together with 10.2, we submit that the finding and or penalty referred to in the regulation, read together with section 10, that we already referred to, it's clear that it refers to the finding at the end of the proceedings and not to decisions prior to the finding. And if one compares that with section 20 of the Act, that provides for the right to appeal to the High Court or to a High Court, there it reads, any person who is aggrieved by any decision of the Council, a professional board or a disciplinary appeal committee. So if one compare the two rights created in terms of the Act, there's clearly a vast difference between the two. The right to approach a High Court is clearly a much wider right provided for than the one in section 10.2 of the Act.
You mean 10.3?
The 10.3 of the Act, sorry, yes.
So what do you say a finding means in 10.3?
That's the finding of that you have committed, you're guilty of acts that constitutes unprofessional conduct.
Well, how does that differ from a decision?
Differing from a decision.
No, but how does it? I mean, if you call it a decision that you've been found guilty of misconduct, or is it a finding?
We would respectfully submit that decision is much wider than finding. Any decision will include the finding of guilty and the penalty, but it's wider. It may include issues of recusal, for instance.
So you're saying the finding of the committee, where it found that there was no bias, the appeal committee will not be able to vary that?
Yeah.
Why not? Because the section 10.3 says it can vary any finding.
No, not Justice Shongwe set aside a finding. If you then go to the regulation together with that, it's a finding or penalty, or the finding or penalty.
Yes, and in your interpretation, finding may mean the finding that there was no bias.
No, we submit that if the legislation chose to use two different concepts, two different expressions, in the one it says a finding, in the regulations it refers to the finding or penalty, and in the section creating the authority or the jurisdiction for the High Court, it refers to any decision. Then there's a clear difference between the two concepts.
Yes, but well, here in this particular case, we don't reach the sanction because the committee had not reached that stage. Am I correct? the sanction of, that is the penalty. It has
Yeah,
not yet.
they haven't, no, there is no finality yet.
Yes. So what I'm trying to understand is why do you say Section 10.3 does not give the committee, the appeal committee, an effective decision in the sense that it can vary whatever finding of the committee?
Because if you look at the regulations, it specifically says the finding and or penalty.
Yes.
It doesn't say whatever finding, it says the finding and or penalty. And if you look further, Justice Shangwe, that's why I respectfully submitted that the interpretation of the rules are also important to assist. If you look at, unfortunately, Justice Shangwe, it appears to be that the correct regulations are not before you now. I don't know whether maybe I should again apologize and ask for an indulgence to make copies of the regulations that were applicable to this trial and make it available to you, or I could just read its two short passages in Regulation 7 that we would submit supports our interpretation in the above regard. And if you then needed to have copies, we will ask you for the indulgence for a short adjournment in order to put it before you. Maybe I can read it to you and then you can decide whether you want copies of that. 7S, Regulation 7.
No, well, I think now you're going to confuse the whole issue. We're dealing with Regulation 8, and if you don't have the Regulation 8 and you feel that you're basing your submissions on it, we better have it.
Justice Shongwe, can I then ask for an indulgence just to arrange that copies of the regulations that were applicable to this trial be put before you?
Will it be so inconveniencing if you proceed and then when you reply
I can do so, and maybe if it's inconvenient then you can decide.
Yes.
I will be able to do it because it's brief passages from the regulations that I would read out for you in the record, which we submit supports the interpretation that we stand for.
Yeah, no, you can ask someone in the meantime to get the regulations, but I think you should proceed.
As you please. Regulation 7 deals with the procedure at an inquiry. And there we have what we submit of significant. Regulation 7S prescribes now how one should go about in preparing the case for the committee. And it says 7S, upon the conclusion of a case, the Professional Conduct Committee shall deliberate thereon in camera and shall thereafter announce its finding. The specific reference to finding in this regulation is clearly its finding at the end of the proceedings of guilty or not guilty of misconduct. And if you then look at T, 7T, the Professional Conduct Committee may make a finding of not guilty even if the accused has pleaded guilty. So again, finding in the regulations clearly refers to the finding of guilty or not guilty we submit, and not to internal or interlocutory types of situations.
So you're saying the dismissal of the recusal application is not a finding? It's
not a finding as was envisaged in Section 10 of the Act, read with Regulation 8.1 of the regulation.
What would it be? What would you classify it as being? The fact that the Professional Conduct Committee found that there was no bias. What would you refer that to as?
That there was no
bias. That they were not going to recuse themselves because they don't consider themselves to be biased.
Well, we submit, one can refer to it as a finding, but it's not a finding as was envisaged in terms of Section 10 and or Regulation 8.1.
So, sorry, Mr. Zillia, the problem I have with that proposition is that you're saying that when the Professional Conduct Committee deals with the issue of bias and rejects it, it's a finding. But when the Appeal Committee deals with it, in terms of Section 20, it somehow is transformed into a decision.
Yes, it's not, yes.
Well, how can that be? In other words, if it's the same issue, and you say that it's dealt with as a finding by the Appeal Committee, but then in terms of Section 20, you've got a right of appeal from any decision. So that would mean that if in fact the Appeal Committee dealt with it and upheld the finding by the Professional Conduct Committee that there was no bias, that would transform what was a finding by the Professional Conduct Committee into a decision by the appeal. The Disciplinary Appeal Committee. So how can that be? In other words, you'd have jurisdiction to go to the High Court in terms of Section 20 from a decision by the Disciplinary Appeal Committee only if it had made a decision. Now you're saying that if the Appeal Committee dealt with the issue of bias and also rejected it, that would now be a decision.
Justice Swain, we submit that for purposes, the Appeal Committee has no jurisdiction to deal with bias.
I understand that, but your argument is based on the difference in the wording between a finding in 10.3 and a decision in Section 20.
Yes.
So to test that proposition, what I'm asking you is that if it's regarded as a finding by the Professional Conduct Committee, in other words, the issue of bias is a finding on your submission. Not so? You're saying that it's a finding that can be dealt with by the, can't be dealt with by the Appeal Committee, right? In other words, that this was not an issue that was envisaged by the Act that could be dealt with by the Appeal Committee because it's a finding. It's only decisions that can be dealt with by the Appeal Committee.
Justice Swain, maybe the difference lies in then the timing. Clearly what is envisaged in Section 10 and the regulations, the jurisdiction of an Appeal Committee, is that it will only obtain its jurisdiction to interfere or to hear appeals after the finding and or penalty has been handed down. Whereas Section 20, and that's maybe the reason for the difference, where it states that you can approach the High Court if you have any problem with any decision, that per definition provides for a situation to
saying that only aspects that are classified as a decision can be appealed from a Professional Conduct Committee to the Appeal Committee.
Can you just repeat it?
Are you saying that only decisions, those that are classified as decisions, are appealable by the Professional Conduct Committee to the Appeal Committee?
Are you not meaning any finding?
Well, I'm wanting to find out this distinction between a finding and a decision.
Let me try and phrase it. First, we have to accept that the legislature intended a difference. Because in Section 10 it refers to finding, and in Section 20 it refers to any decision. That's we submit the starting point. Secondly, we submit that any decision is a wider concept by way of understanding than the finding stroke penalty. So we submit that clearly what the legislature intended, and that's clear from the language, is that the High Court has a different jurisdiction than the Appeal Committee, and it is indeed a wider discretion and or wider jurisdiction than the Appeal Committee. Now, we submit there's only two bases to understand that. Our first submission is that the Appeal Committee's jurisdiction, if one look at 10.2 and 10.3 and the regulations, is that it will only have jurisdiction as to the finding of guilty or not guilty and the penalty. And it will have no interim jurisdiction.
You see, that what confuses me, the problem is, how do you draw a distinction between a finding and a decision in regard to determining the appeal committee's powers? Because you're saying that they've got jurisdiction to deal with a finding but not a decision.
Well, it is...
Because you're drawing the inference, you're saying that decision means a wider ground of appeal for the High Court, finding means a narrower ground of appeal.
Yes.
Right. So you're saying that their refusal to recuse is a finding or a decision?
I would say that's a decision.
Which can be varied by the appeal committee.
The problem is just, Sean, where we are confronted with a situation that the legislature chose to use different concepts.
Yes, but you are saying it's a decision. The finding of bias is a decision, which can be varied by an appeal committee. Am I right or wrong?
I would say that the appeal committee will only have jurisdiction, as we read the Act together with the regulations, to make decisions on the correctness of a finding of guilty or not guilty, and or the penalty if there was a penalty.
Yes, but you're not answering me. My question is, the decision of the committee, the Professional Conduct Committee, finding against bias, you say it's a decision, am I correct?
Yes.
And my question is, can the appeal committee vary that decision?
No.
In terms of section 10.3?
No, they can't.
Why not?
Because we say they are limited to the finding of guilty or not guilty to misconduct and or the penalty.
Well, what is the difference between a finding of guilty and not guilty and the finding of bias? What's the difference?
Well, if the problem that there is, if you read again 7S, Justice Shongwe, it's upon the conclusion of a case of the Professional Conduct Committee shall deliberate thereon in camera and shall thereafter announce its finding. And again in 8, a finding of not guilty. So it appears to us that the use of finding in the Act and regulations was limited to the finding at the end. Otherwise, 7S and 17 would not make sense. And therefore, we submit it was necessary then for the legislature to use other language in section 20, creating the jurisdiction for the High Court. And therefore, it didn't state in section 20 that any person who is aggrieved by any finding of the council, it there states aggrieved by any decision of the council. For instance, if one requests a postponement in the conduct committee and the conduct committee refuses it, then you can't appeal it at that stage to the appeal committee. But you can approach the High Court, because the refusal of the conduct committee of the application for postponement constitute a decision made by them.
Mr. Phillips, if I understand you, you're saying that a finding, as it is on section 10.3 and the regulation 8.1, you're saying that it's a finding of guilt or not guilt.
Yes.
And the reason you say is because regulation 7S refers to a finding as a finding of guilt,
yes,
or not guilty.
And it refers to a finding at the end of the proceedings.
Yes, and further you say that because, again, on regulation 8.1, it says a finding and or a penalty. So
yes,
that is your reason to say that
that's
finding in this two, in 10.3 yes, and 8.1 should only be
yes,
regarded as
Yes.
A finding of guilt and nothing else.
At the end of the proceedings, yes.
Why are you saying that?
Because of the context. Unfortunately, Justice, it is difficult to explain because I can understand in the ordinary English you can say, but in the end the court delivered a decision. Maybe you can say that. But we are confronted with a situation that the legislature in the same act chose to use different concepts in section 10 and section 20. And then one has to attempt to provide a solution by interpreting these sections to make sense. But the starting point is the legislature chose to use different concepts, and clearly the legislature chose to use a wider concept when it dealt with the jurisdiction of the court in comparison to when they dealt with the jurisdiction of the appeal committee.
Mr. Sirian, do the different concepts, well, may I put it you this way, are the different concepts really material? Because as I understand your argument, as my sister Mauro had put to you, if your argument is that the finding that's envisaged in section 10.3 relates only to a finding of guilt or innocence or a penalty, then logically such a finding will never get to the section 20 stage, because the appeal committee wouldn't have had jurisdiction.
Yes.
So what does it matter if it's a decision or a finding in section 20?
Yes, I think I
Your
agree.
argument is it's never going to get there.
I think I agree with you, Justice, but of course we are confronted with the fact that there are those concepts and one has to try and interpret them. But what I agree with you, even if the legislature chose to use the same language in 10 and 20, it would not make any difference to our argument. We only say that the difference in language strengthens our argument.
Can I take you to another point which relates to the earlier application, if I can just ask you this. The High Court found, as I understood its finding, that the decision, or rather let's say that its ruling not to recuse, for the particular members not to recuse themselves, was a finding. Yes? And it said that finding was a finding that could be appealed in terms of section 10.3. Is that correct?
That
Yes.
was what's
Now, on the High Court's approach, only that finding you must then approach, on the High Court's approach, you must then go to an appeal committee as envisaged in section 10.3.
That was the finding, yes.
But if that is so, then the application before BAM-J was incompetent.
Yes. Yes,
Because then it means that if you couldn't go,
if we couldn't approach the
couldn't
court
approach the court
then we
on the
couldn't
recusal.
approach the court on the refusal to provide us with
the information.
and or the postponement.
so where does that leave the High Court's finding?
Well, we submit that illustrates that the High Court keeps its jurisdiction in midstream. When we requested the information relating to the membership of the members to certain organizations, and they refused to provide us with the information, we approached the High Court, and in two different instances, two different courts, in fact, found that we were entitled to approach the court and granted the interdict.
Can I put the proposition in a different way? Could you be met with an argument under section 7.2, but you have an internal remedy? You don't need this information as to whether the two persons were members of the organizations in question, and therefore you must wait and go to the section 10.3 And the same applies to the question of, there were two issues that had to be decided. One was whether the inquiry had to be postponed, and first issue was whether they had to provide the information, and the second issue whether the inquiry had to be postponed. So could it be said, well, this isn't, you've got an effective internal remedy, go to the section 10.3 appellate body and get your relief there, because that seems to be lesser relief than the recusal.
Well, it was never suggested, and I would submit correctly so, they could never expect from us to at that stage approach the appeal committee.
Do I understand your submission that the point was never taken by the
It
respondent?
was never taken. And
why should we be dealing with that now? Aren't we straying now? Because now that decision of BAM is not before this court.
Absolutely.
So even if you can draw an analogy, you know, it won't help this court, because what we are confronted here with, it's a decision of the Professional Conduct Committee on the issue of bias, as you put it in the beginning, on the issue of bias.
Justice Shongwe, I would respectfully submit it is indeed relevant and to some extent important, because that illustrates the jurisdiction of the High Court in terms of Section 20.
Yeah, but that was not debated in the High Court, whether or not you have to go to the, as you put it, I mean, the respondent, they didn't raise that issue.
But Justice Shongwe, it does illustrate the point that it would not be an effective internal remedy to expect the appellant at that stage to approach the appeal committee to force the members to disclose their membership to certain organizations.
Well,
or the question, and that's why I raised with respect the example of postponement. I've, with great respect, never encountered any suggestion in many years in tribunal situations where one requests, for instance, a postponement and the tribunal refuses it, that then you then go to the appeal committee or appeal mechanism created in the Act.
Well, it depends whether it's appealable or not. It may be a point which is not appealable, which need not go to
but it's reviewable, and that's another important point. The question whether the appeal committee has any review powers.
Mr. Cillier, the proposition that my brother Skip has put to you, in other words, if you say that finding means a finding of guilt or the finding of a penalty, and that's distinct from the wording of Section 20, a decision, then my brother Skip has put to you that means that a finding of guilt or a penalty can never get before the appeal committee.
Before the appeal committee?
Yes, because they only deal with decisions. In other words,
referring now to the appeal committee or the High Court?
No, the appeal committee. Your argument is that the use of finding in Section 10.3 and the use of decision in Section 20 is significant. And there's a distinction to be drawn between the use of those two terms. And as I understood you to say is that findings only refer to findings of guilt or innocence or a finding of what the penalty should be. Right.
Yes.
Now, Section 20 says any person who's aggrieved by any decision of the
High Court,
yes, of the disciplinary appeal committee.
any decision of the council, a professional board or a disciplinary appeal.
So what you're saying is that finding of this nature cannot get before the appeal committee because it doesn't fall within the jurisdiction. It's not a finding for purposes of Section 10.3.
I'm not sure I follow you. A finding must always go, a finding or penalty as we submit must always go to the appeal committee first.
Yes, but you're saying that the finding of a refusal to recuse is not a finding within the definition of 10.3.
Yes, it will never be argued before the appeal committee.
And how do you describe that? the refusal to recuse in the context of the nomenclature used in the Act between a distinction between a finding and a decision, what would you say that would be described as?
Justice Swain, I would respectfully submit.
Because it's got to be one or the other, doesn't it?
Yes, I would respectfully submit the use of the language by the legislature is indeed quite vague. But the fact is they have chosen to use different concepts. I would respectfully submit, if one read the Act together with the regulations, the appeal committee's jurisdiction is limited to the findings of professional conduct, misconduct,
yes,
and or the penalty. They are confined to that.
So
if one has any other
So those are called findings. That's what your submission is. Those are called findings.
Those are for purposes of this Act,
yes,
called findings.
So what is the refusal to recuse? How do you describe that?
It's not a finding for purposes of this Act.
Well, what is it described as then?
Decision.
So it's a decision.
I'm sorry, maybe, if you don't mind. I'm getting a bit confused now. Earlier on, you said that the recusal application deals with a finding. Said they found that they are not biased. Now here now you're saying, you seem to be suggesting that it's not a finding but a decision.
Justice Sariti, what I'm trying to convey is that in the ordinary use of language, I suppose the refusal to recuse can be said to be a finding. But for purposes of the Act and the construction of this Act, and read with the regulations, then the refusal of the committee not to recuse themselves doesn't qualify to be referred to as a finding as is envisaged in section 10.3. That's
what does it qualify to be called?
Sorry, Justice?
What should it be called? Or what is it being called?
I don't know. You could call it with respect whatever you want.
Okay, thank you.
Can I understand here? You're saying a finding as far as section 10.3 and regulation 8.1 is concerned relates to the finding of guilt or not guilt, yes, and also to the penalty. But this finding can also find itself to become a decision in section 20.
Yes, because the High Court's jurisdiction is much wider than it includes the appeal committee's jurisdiction, but it goes beyond that.
So a finding can be a decision, but a decision cannot be a finding.
For purposes of this Act. I think with great respect, we pay too much attention in this difference. The question in the end to be decided is whether we could approach the appeal committee instead of the High Court to complain or to appeal against the refusal to recuse. That's the question.
But you see, Mr. Sillett, you say we're paying too much attention to the difference between finding and decision, but that is the heart of your argument, the distinction you draw between those two terms.
Well,
is it not?
It is to illustrate the point, Justice Swain, but in the end, that is the question that I formulated. Then we said, why do we say that? We say it for various reasons. We said the starting point, the first point is to look at the Act together with the regulations and see that the legislature indeed used different language to describe the jurisdiction of the appeal committee on the one side and the High Court on the other side. That's we say the starting point.
Yes, but then you ask us to draw the inference that because of the change in wording, that a finding of a refusal to recuse is not the finding that is envisaged by section 10.3, and therefore it's not something that you can take to the appeal committee.
Yeah, we say with respect that the appeal stroke review of the decision to refuse to recuse themselves, we say we could not take to the appeal committee.
Yes, I understand that, but I want to know, anyway, I've asked you that. how you describe a refusal to recuse. You say you can call it whatever you like.
For purposes of this act, I'll describe it as then a decision, because that is the language that the legislature used.
Well, shall we then proceed to the next point, Mr. Celia? We have heard enough on decision and finding, and we will see at the end. But now, can you go to the next point?
We can, Justice Shongwe. The next issue is, of course, the question whether the appeal committee has the jurisdiction to hear reviews and or then appeals in the wide sense, because there's sometimes the legislature do use appeal in a wider sense than the strict appeal that we usually deal with in court. We say, with respect, that the appeal committee as a creature of statute will be limited in jurisdiction to what is specifically prescribed to it. And we say that they don't have any review jurisdiction at all, whereas the High Court, of course, have review jurisdiction as well. And we respectfully submit that the application that we brought was a review application. It wasn't an appeal in even a wide sense. And there we submit there's a very important factor there, where the trial judge, with respect, made a mistake. A part of his reasoning, a very important part of his reasoning for his decision was the fact that all the material that was before the court would have been before the appeal committee as well, and therefore he inferred that the appeal committee would have had jurisdiction. We say, with respect, factually he was wrong, because a very important part of the application before the court, the review application before the court, in fact had facts and a basis that was never part of the record in the inquiry.
But you see, the court are quite phrased in this way, at page 791, paragraph 31 of the judgment. And the learned judge concluded in line 3, no power of review is required to do so, because the question is not whether the committee's finding is lawful, but whether it is correct.
You read from paragraph, Judge?
Paragraph 31, page 791, third line.
Yes, but then it further motivates it by saying that all the material was would have been before the...
Yes, but what is your submission in that regard?
Well, that's the wrong starting point, because all the facts that we relied on would never have been before the appeal committee.
Why not? The whole record will go there.
Yeah, no, Justice, if you look, for instance, if you take volume 1, page 80, there was a whole section.
Page?
Page 80 of volume 1, Justice Remedies. There was a heading, conduct of respondent during High Court proceedings. That dealt with, inter alia, the fact that the attorneys who were the prosecutors in this inquiry acted on behalf of the two respondents during the High Court proceedings. And we said that was an illustration of, or could create a perception of bias as is envisaged in the legal principles relating to recusal. Now those issues will never be before the appeal committee because it doesn't form part of the record of the inquiry.
But when those your submissions, when you were bringing an application for bias, when those your submissions that there was an irregularity about attorneys who were also prosecuted?
Yes, those were the...
So that will be part of the record which to the appeal committee. Your submissions will be part of the record.
No, Justice, sorry, Sean, I misunderstood you. It was not part of the argument before the committee.
You didn't argue that?
It was not, because it didn't occur at that stage. It only occurred later.
So it's not part of your application for recusal?
It was not part of our application for recusal before the committee.
Yes.
Let me just make sure. Yeah, no, sorry, it was mentioned, but it wasn't part of the record.
Yes, but now why would it be relevant? Why would it be relevant when you're dealing with an appeal against a refusal to recuse themselves?
Well, it would not be before the appeal committee. That is our difficulty. Those are important facts that was before court, that a court on review could deal with, but it would never have been and will not be before the appeal committee at the end of the proceedings. Because those were part of the High Court application papers. And the High Court application record will never form part of the material to put before the appeal committee.
Yes, but as a procedural measure, you would go to the appeal committee and deal with whatever was before the conduct committee.
Yes.
If you don't find joy there, then you can go to the High Court. But the strict procedure in terms of the act, the regulation, is that there is an internal remedy that you have to go through before you go to court.
The only point we make, Justice Shongwe, that these facts set out at some length in the application papers before the High Court will not be part of the record before the appeal committee. So if we argue the recusal issue before the appeal committee, we would be restricted in the grounds for the recusal in the sense that they would not be, they would not have the record of the High Court illustrating these issues before them.
Mr. Sir, can I take you back to your argument, which is really, as I see at the heart of the case, as to whether the remedy in section 10.3 is effective. Because if it's not effective, you win.
Yes.
If it is effective, you lose.
Yes.
Not so.
Well, if I can show exceptional circumstances, but on the point I agree with you. Yes.
Now, do you have the Kayabi decision?
Yes.
Do you have a copy of the Kayabi decision?
Yes,
Kayabi?
we have.
Can you please turn to paragraph 42 of that decision? If you go to paragraph 41, do you have it, Mr. Silier?
It seems to be, are you referring me to paragraph 41?
Go first to paragraph 41 of Koyabe.
I have the Koyabe decision, but it seems to me we only have, sorry, my file, I only have the copies of the paragraphs that we have the respondent referred to. Let me just see. Now, I'm sorry, Justice. I don't have...
All right, I'll read it to you and you can respond to the propositions that I want to put to you.
Yes, please.
In paragraph 41, the starting Justice Mauro says a useful analogous requirement in international law is the customary international law duty to exhaust available domestic remedies before approaching an international tribunal. But she says that in the context of international law. But in paragraph 42, she says that the approach of the African Commission on Human and People's Rights is that a remedy must be available, effective, and sufficient.
Yes.
We're only concerned with whether the remedy is effective and sufficient. Are we agreed?
Yeah.
Now, Justice Mauro then says in paragraph 44, a remedy will be effective if it is objectively implemented, taking into account the relevant principles and values of administrative justice present in the Constitution and our law. That's what she says. Yes. But if we go back to paragraph 41, she firstly says that she refers to international law and she says that it must be effective and sufficient to redress the complaint. And then in paragraph 45, she concludes. Paragraph 45, she says, as the international jurisprudence illustrates, judicial enforcement of the duty to exhaust internal remedies in giving content to the exceptional circumstances exemption must consider the availability, effectiveness, and adequacy of the remedy. So what Justice Mauro does there, as I see it, is that she looks at the international law. She sees what it says, and she says that she concludes that as in the international jurisprudence illustrates, the judicial enforcement of the duty to exhaust internal remedies gives content to the exceptional circumstances rule. One of the international authorities that she refers to in paragraph 42, at footnote 41, is a judgment by Mccarthy versus Madigan, a judgment by the US Supreme Court. And in that judgment, which you will find at footnote 41, Justice Blackmun recognized certain exceptions to the exhaustion doctrine. One of those exceptions is where the administrative body is biased.
Yes.
Now, in the light of that, where does that leave in your submission the decision of the court à quo? Bearing in mind the Constitutional Court has endorsed the international approach and has endorsed the international exceptions to the exhaustion doctrine.
We submit that you find the same approach in the work of J.R. DeVille, Justice, in the Judicial Review of Administrative Action in South Africa, at page 452. It states, an application for review before a final decision is taken is often brought in the case of alleged bias or a reasonable apprehension of bias on the part of the decision maker. Because of the potential prejudice that may be suffered by a person in such circumstances, objection is seldom taken to such an application. So we submit, when it goes to the jurisdictional factor, the jurisdiction of a specific tribunal, to hear the matter, because that's in essence what we have before you now, that only the High Court would have had the jurisdiction to decide on that issue. And
yes, but what the proposition I put to you earlier is that if in fact a decision is affected by bias, it renders the proceedings a nullity.
yes,
And according to the case of this court that I put to you, those proceedings then have to be set aside.
yes, that's
Right. So can one say that in terms of section 10.3, the appeal committee has the power not only to vary or set aside a finding, but also the power to set aside the entire proceedings of the Professional Conduct Committee?
well, we again submit definitely not.
Because if there is a finding of that there should be a recusal, the proceedings are a nullity,
Yeah.
but they still exist until such time as they are set aside by way of review.
I agree with you. Yes.
Can I lastly, on this point, Mr. Cillier, just give you a practical example, just to test the proposition of the finding of the court à quo. Suppose Dr. Smith is charged with professional misconduct before a professional conduct committee. On the morning of the disciplinary inquiry, he sees the complainant and the chairperson having breakfast at a restaurant.
Yes.
He also sees the complainant handing over a brown envelope to the chairperson. At the inquiry, and before any evidence is adduced, I should say, his attorney brings a formal application for the recusal of the chairperson on the ground of bias. The application is refused. Now, on the reasoning of the court, I quote, am I correct in saying that the appeal committee then has jurisdiction to consider an appeal against the decision of the Professional Conduct Committee to dismiss Dr. Smith's recusal application on the finding of the court, I quote. That means, obviously, that Dr. Smith cannot approach a high court for review. And he must go through the whole inquiry and then lodge an appeal with the appeal committee under Section 10.3.
Yes.
Now, in Koyabi, Justice Mauro says that the appeal remedy must be effective and that its pursuit must not be futile.
Yes.
What is your submission as to whether, in the example I gave you, the remedy is effective, firstly, and secondly, whether its pursuit would be futile or not?
Well, it would be absolutely futile in our instance, in our case, and that stems back far in our law, Justice Schippers. I would say the starting point of this issue of effectiveness and immediate action can be traced down to the decision of Vessels. You just bear with me. Vessels versus General Court Martial and another, 1954 one decision, SA 220, brackets E, where His Lordship Justice Reynolds said the following on page 222 A. But it seems, well, he first starts off by saying, but the decision quoted are cases dealing with the power of the court to intervene by way of review at the final stage and do not deal with the power to interfere at this stage. But it seems to me on principle that the court's power must be exactly the same now, that's now prior to the finalization, as at the final stage. It would be strange indeed if an irregularity could occur and the court not correct it at the proper stage. If the court could not do that and the irregularity was fundamental and so affected all future proceedings, it would mean that if the court had no power to correct it safe at the final stage, these proceedings could go on and become abortive at the end, costing all the parties a lot. And we respectfully submit that's the starting point. And that raised another question. The question whether we could immediately appeal to the appeal committee. Because if we could not appeal immediately to the appeal committee, then it would not have been an effective remedy.
What would stop you from appealing immediately?
Well, the trial judge found that we couldn't. He's vague. He didn't make it as a finding. He mentioned it, and then, of course, quite interesting. If you look at the
but now you're dealing with the issue of prematurity.
not really. I think
No, that what you quoted, you're dealing with prematurity there. We're dealing with the issue of whether it's an effective remedy.
But it overlaps. We submit, Justice Swain.
Yes, my brother Skippers was putting to a proposition in regard to whether this is an effective remedy.
Yes, I fully agree with what Justice Skipper said, and I would submit in our instance it would definitely not be an effective remedy. And I just want to expand on that, and I want to refer you, for instance, to
Why do you say it would not be an effective remedy?
Well, I would say, first of all, one will have to decide whether one could approach the appeal committee piecemeal. In other words, immediately.
That's prematurity again. I just want to know, not an effective remedy.
No, Justice Swain, with great respect, I differ from you.
So you say the prematurity is essential to the issue of the effectiveness?
Because of this, the peculiar facts of this case, where the Act provides that if there's a suspension or removal from the role, it's effective immediately, and appeal proceedings won't suspend that.
Yeah, but that you advance as far as the exceptional circumstances.
Not only, it's also relevant to the question whether it's an effective remedy. Because if you can't approach the appeal committee immediately, then it's not effective, because then you will have to finish the trial, and after the trial has been finished, you are maybe suspended or removed from the role. You can't practice, and you have to wait for a year or whatever the time period is concerned that you can get the matter through the appeal committee and the High Court. And we say you must look at that as well in order to determine whether it is an effective remedy. And that's exactly, if you look at the heads of argument on behalf of the respondent, if I can refer you to their heads, in paragraph 29.2.
What page is that?
I don't think their heads has been down in Justice.
Their heads in this
their
court.
Heads of argument.
In
yes.
this court.
Paragraph 29.2. They ask for an order. They say the Honourable Court is also requested to find that the appellant is not entitled to exhaust his remedy of internal appeal regarding the appeal against the recusal application before the proceedings have been completed before the committee. Now, we submit in this regard the following. If they thereby submit or suggest that we are not entitled to approach the appeal committee at this stage, before finalisation, and you are with them in that regard, then it means approaching the appeal committee is not an effective remedy.
No, but this refers to prematurity. It only deals with prematurity, because in this particular case, I mean, the sanction had not been imposed yet, so the appeal. Internal appeal will go to the committee. The appeal committee will then decide for or against. If it is with your client, then it means the whole thing starts de novo. If it's not with your client, then it goes back to the committee, and then the committee deals with.
You are right, Justice Shogbe, but it's extremely important to decide when I will be, or the appellant will be entitled to approach the appeal committee. If the position is that you are entitled to approach the High Court piecemeal before the finalisation, then it's a very effective remedy, because then I don't have to wait till they convict me and remove my name from the roll, and I'm from the roll for the year or 2 years that the appeal procedure takes.
Well,
so then it's effective.
Yes, but Section 10.4 deals with that. That a decision of a Professional Conduct Committee shall be of force and effect from the date determined by the Professional Conduct Committee. So the Professional Conduct Committee could say, well, this shall not come into effect until you've exhausted your appeal process. Yes.
But then we have to rely on the biased committee. And
no, that's a different inquiry. You're saying that once they make the decision, if they do make the decision to suspend or strike off your client, then he's immediately prejudiced. But there is provision made for the effect of that to be deferred.
But Justice Swain, we submit that to leave the appellant in the hands of a biased committee is not an effective remedy. Let's with great respect, illustrate it by a harsh example. If, for instance, during the proceedings, the presiding chairperson tells the accused person, the person against whom the inquiry is conducted, listen, I don't like you. I suspect you have an affair with my wife, and I am going to see to it that you are destroyed, I'm going to convict you, and I'm going to suspend you, or I'm going to remove you from the role. Those are the facts. Must that appellant, or must that person now go through the whole proceedings, being removed from the role, and then wait for, and get an order from the chairperson to say that the effect of the penalty will be immediate? Must he now be removed from the role for a year or two, until, if the appeal committee then has jurisdiction, to set the proceedings aside? So what we say is very important to effectiveness as well, is whether the appeal committee will have the jurisdiction to hear, like a court, the appeal on a piecemeal basis. Because clearly, although the courts are reluctant to allow it under circumstances, for instance in bias proceedings, the courts do allow piecemeal appeals or reviews. So all we say is, if the appeal committee does not have the right or the procedure available to hear us now, then the remedy to the appeal commission committee is not effective.
Shall we take an adjournment at this stage? Court will adjourn 15 minutes.